Hello, everybody. Welcome back. We are going to continue. This is the second segment of our legal navigating legal resources episode. We previously discussed understanding habeas corpus, and we had an in-depth discussion about that. I know there's still more that you have to highlight about that, Mr. Ford. And I want you to finish, continue to highlight that, but then I want you to go into the void judgment petitions and help us to understand that process. From what I understand, is that the void judgment petitions can be challenged in a court's judgment. And it's unlike the appeals, which focus on errors made during the trial. So I'm assuming the void judgment petitions argue that the court lacked jurisdiction or authority to make the decisions. So I want you to really speak to that in depth and help us to understand, because I think that's where some of us are in a legal aspect. I think when we file the petition with the court for the habeas corpus, then we come into the petitions, and I think that's where we lose sight, and we need somebody to assist us, guide us, that understands the legal system. So if you can highlight this, I appreciate it.
Yeah, so basically, to understand that, you have to understand the fundamentals of law, all right? Especially when you're dealing with the criminal procedure, or anytime you're interacting with the courts, or just being a citizen of the United States, or whatever your status is in relation to the United States or your own government. So you have to think about all cases. Basically, they break down into two parts that you have to be bringing up, or you have to have knowledge of in the beginning, which is your status and jurisdiction. So your status, people don't understand what status is. So a lot of times when they come into, say, the law library, I say, well, what is your status? And I know I'm saying these things, but I know them through the years. First, I got to pay respect to the brothers that were building with me and teaching me along the way, and all the struggles I had through life and everything that brought me to that point. So I want to give respect to that first. I don't want you to think it's all coming just from my head, but it comes through the wall. But you have to know what your status is. So when you ask somebody, what is your status? If I say to you, what is your status? What would you say that it is? Let me ask you, DK, what is your status?
Explain to me, what do you mean? What is my status?
Well, even right there, that's fine. By you saying that you don't know what I mean. But when I tell you that that's a fundamental issue that we have to know of, and we don't know what it is, then we're already at a loss, because that means someone's going to establish our status, or we're going to accidentally establish our status. So your status is basically who are you in relation to yourself or the law. So some people say, okay, when I press them a little bit, they say, okay, yeah, I'm a citizen. And I don't know, because I don't know if you're a citizen. Just because you sitting in this chair doesn't mean that you're a citizen of the United States.
Right.
Because there's a lot of people that are in the prison that are not citizens of the United States.
Right.
So your status, at least to start, are you a citizen? Okay, now, are you a citizen? Would you determine yourself to be a citizen of this state and the United States?
Yeah.
Okay. Are you? So you would say yes. Are you? Have you been convicted of a felony? So that, some people don't know if they've been, or if they have or have not, or whatever, but that can diminish whatever your status is. So you have to know what that is. You have to know some of your statuses deals with your age. It deals with, okay, are you a juvenile? Are you over 18, or are you under 18? So your status can determine who has jurisdiction, which is the authority to hear your issue. So if you don't know that and you're going in and they're determining all that for you, or you are accidentally establishing that on the record, because when you come into the court, they ask you a lot of questions, and people they're so happy to answer those questions, but they're not thinking about what they are saying when they are answering those questions.
Right.
So there's so many issues that deal with status, but your status can determine jurisdiction. So if you were a citizen, it determines if the court has jurisdiction. If you are juvenile, a different court has jurisdiction. If you are a felon, then your status is diminished in whichever court you're in. So you're in a state what they call civil death, or civilly dead. You're civilly dead. It means you're dead in the eyes of the law. So if you don't understand those things, and then you start going into the court, into that realm, what looks like it's illegal to you, but it might be so-called legal according to the way that the law is broken down based upon your status. And you might say, just like, let me give you an example real quick. If you're in a prison, or if you're in society and everyone's outside saying, man, we have a First Amendment right to do this, and we have a Second Amendment right to do this, and we have a 14th Amendment right for this, and you got a mass of people, and they just all join into this rally. But when you break it down, probably a lot of those people don't have those rights.
Because they don't
You might have a lot of immigrants in there. You might have a lot of different people of different status. And when you get down to it, out of 100 people, probably only 10 people had those rights. So they didn't even have the rights. They just got caught up in the sweep of saying that we have these rights, and neither one of them had those rights.
Right.
So when you go through the legal process, they're actually determining, without explaining to you, whether you actually have those rights based on what they know about you, the way you're answering the questions. They're determining how we're going to deal with your case. So when that is set up in the beginning, status and jurisdiction, and then everything else that happens after that, you might think it's a total violation, like everything that happened to you was a violation, but in reality, it was based on your status that you didn't realize that you were supposed to establish. So jurisdiction deals with the authority of the court to rule, make judgments, or anything. So when you are challenging a case on a void judgment petition, you're basically saying the court did not have authority to do what they did. They did not have jurisdiction. So if it's a jurisdictional issue can be raised at any time, in any court, in any manner. So it basically says that the judgment is void. Like, what you have is what you call due process. So due process is basically, let's just say, the process that is due at every stage of the proceeding. So let's say you take a proceeding and you break it into 10 parts. At every stage, something is supposed to be done. A right is supposed to be guaranteed. A procedure is supposed to be followed. If at any point along that way, something is violated, something was not guaranteed, something wasn't, offered, then that is where the proceeding stops. So all of the other stages after that point are void, including the judgment of conviction and the sentence and anything else. So the case must be brought back to the point where due process was being followed and due process was violated. So that is what is fundamental to all of the actions, basically, in the criminal process, even on appeal. That's what you are saying. What you are explaining on appeal is that at this stage, there was a violation of my due process. Therefore, the court was not allowed to proceed to any subsequent stage.
Right.
So on appeal, when they say, okay, right, we find that the violation occurred at stage 6, then the case must go back to stage 6.
Right.
No matter what happened after that.
Right.
So that's what you're saying on appeal. That's what you're saying on habeas corpus. That's what you're saying on a void judgment petition.
Right.
Now, sometimes in the state, you're kind of misdirected off of the issue of the fundamentality of your status and jurisdiction, and they start going to codes and things like that. They try to clean up stuff, even though they're still violating your rights. But you got to stick to those fundamental issues. So you have to understand the law. But
Okay. I don't know if that was on your end or my end, but we are still recording. Continue.
okay, so if you are going through, let's go back to the appellate process again. And one of the things that you have to do is be organized if you're going to try to fight your case.
Right.
And so what you want to do is write down what you think should have been presented. So you make your list. This is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 things that were important to my case. The officer, when he arrested me, didn't read me my rights. I wanted to remain silent, but they made me make statements. There was an identification in my case, and I wanted it suppressed because it was impermissibly suggested.
Right.
There was a search, and it violated my Fourth Amendment rights, or it violated, my rights against illegal search and seizure, plain view doctrine, and things like that. They went in my pants on the street. They're not allowed to strip search you on the street. They got to take you to private areas. So they went in my car without asking. They when they took me to the jail, they a multitude of things. They denied me access to counsel. When I went to court, my lawyer, he didn't object to these things that I told him. All these things I just now named, he didn't mention any one of those things during the trial process. He didn't file any motions. He didn't say anything. He just moved on like nothing happened. These are the issues that he did bring up. He brought up his own issues. He had the issue that before trial, he brought up this thing. During trial, he made these 3 objections. During trial, a witness that I wanted to testify was not there. My lawyer did not secure. This part of my trial, the lawyer solicited damaging information from a witness against me. Nobody put it up there. My lawyer just carelessly brought that information in. My lawyer did not do a good job in objecting to witnesses' testimony. At the end of the trial, my lawyer didn't renew objections. The prosecutor did these negative things. The judge did these negative things. The jury wasn't picked right. The voir dire process wasn't right. So you have to be familiar with all of these different stages and steps. The jury instructions were bad. I think a lesser included offense should have been included. A juror should have been struck, or a juror became disqualified during the trial because of a certain situation. So at the end of your trial, and then what your lawyer argued in closing, what the prosecutor argued in closing, was his argument legal or was it lawful?
Right.
Did your lawyer argue what he should have argued? And did the jury receive the correct instructions?
Right.
So was the indictment, let's go all the way back, was the indictment right? Because a lot of times there's problems with the indictment. So was the grand jury hearing proper? So at the end of this whole thing, you got, these are your issues. Now you got to look and see, what did your lawyer bring up sufficiently? What did he raise on appeal out of these issues that you brought up? And then you might say, okay, my lawyer brought up, the issues that my lawyer brought up in this box down here. He brought up 1, 2, 3 things out of the 5 things that he could have brought up on appeal. So why didn't you bring these 2 other issues up? He says these weren't strong. Do you agree or disagree? I disagree. I think this was a strong issue that he had enough evidence to bring up on appeal. So I'm going to say that that goes in my lawyer's error box. He was ineffective. So now if I look at all these other issues up top and say he should have also brought these situations up, he should have questioned this witness. He should have said something about the search and seizure. He should have said something about the suppression. Then these are other reasons why I think he was ineffective. So now you got to let his process go through. But see, one thing is when you know this stuff going in, then now you know what to say when you're in the criminal process. So if your lawyer isn't making an objection or whatever, you don't have to be silent. You know what I'm saying? You can intervene. You should, if you know your status, and you know you should be saying something. You should be, hey, this isn't right. You know, my lawyer just now told me to sign this plea deal, and he told me that I was only going to get 2 years, but now you're saying 10 years. Like, they didn't write that on this piece of paper. You know, they didn't say, they promised me something, but it's not on this paper. A lot of people's lawyers are always like, don't say anything. I got this right. And instead, you're just being quiet because you're listening to him, and the whole time he's sending you down the river.
Right,
When they go back, the first thing they're going to go to is your colloquy, and they're going to say, well, right here we asked, did you have anything that you wanted to bring up? Did your lawyer represent you correctly? This, that. And you said, yeah, everything was great. So why are you saying something different now? We asked you this because my lawyer was promising me these things, but we asked you right here, did your lawyer or anybody promise you anything? And you said no. So why did you say that if in fact that was the case? So what I'm saying is, don't be silent, you know, take notes. If the So if there was a promise and your lawyer or the prosecution or whatever, you know, hid that from the court, then you have to voice, you have to say something, you have to put it on the record. So if your lawyer doesn't say it, make sure that you say it. Because even I would ask you, if you come to the law library inside the prison, to say, well, right here, you're saying that you had this whole conversation with your lawyer, like, where is it at? Oh man, you know, I didn't ever write it down. I ain't record it. I ain't do nothing. Lord, why you got this cell phone? Like, you know, record stuff. If you was out on the street before a trial and you were talking to your lawyer, record the conversations.
Right.
You know, document everything so that you could bring it up later, because it will help you later on if something goes wrong. Because they're promising you all kinds of stuff, or they're undermining your case, the sandbag, and they're telling you that it's not a big deal. Then you get walked in, you get hit in the face with a baseball bat, and it's like, what happened?
Right.
So make sure you are speaking up. You have a voice. So when you get through all those issues, and you have these issues that you raise on appeal, you go through the 1, 2, 3 process, which is the first 1-judge panel in the Court of Appeals, the 3-judge panel in the Court of Appeals, and then the petition for appeal to the Supreme Court of Virginia, which is the court of last resort in this state. And if you need to file a petition for rehearing from the denial of the Supreme Court of Virginia decision, then that is the time that now you have an option to file in the habeas corpus. The habeas corpus in Virginia deals with ineffective assisted counsel claims. So ineffective assisted counsel claims cannot be brought up on the appellate process unless they were raised at trial, which usually they're not, because your lawyer was representing. So the only way you could really get it in is if you objected and then you filed your own petition for appeal, because your lawyer is not going to raise ineffective assisted counsel claims against himself. So those are reserved for the habeas corpus process. So while your appeal is going on, don't just sit on your hands. Be preparing your habeas corpus. So take those, how many ever issues it was, say 5 or 10, and prepare them for when the time comes that your appeal is denied by the Supreme Court of Virginia, to be ready to file your habeas corpus. Now, in Virginia, you have 2 years total time to file a habeas corpus in the state. But if you want to have your habeas corpus reviewed later on in the federal court, you have to file it within 1 year, because the federal court only gives you 1 year. So they total the time. So if let's just say after your appeal is denied, you take 8 months to file your habeas corpus, the clock stops in the federal court at 8 months.
Right.
So when you're done with the a habeas corpus process in the state, the clock will start back up and you have 4 months left to file your federal habeas corpus 2254 petition. So, that's just something you have to understand. There's two clocks that's running at the same time. And when you file your state habeas, it stops the clock so long as you are going through the habeas corpus process, filing timely appeals, and getting all the way to the Supreme Court of Virginia. If you fail in anywhere of those processes, then the clock's going to start up at that failure. So then you got to know that your time is running out for your federal clock. Now that change, it used to be that you had unlimited time to file a habeas corpus in the federal court. Now they changed it after the Anti-Terrorism Effective Death Penalty Act, and they changed it that you only have 1 year to file it from the state court to the federal court on a 2254 petition. So basically what that is a statement that gives the jurisdiction, or it allows the federal court to have jurisdiction to look at what the state did. They don't just jump in and intervene into the state action. It's not an appeal. It is a process that the federal court uses to determine whether it can gain jurisdiction to look at a constitutional violation of federal law. So if the state some kind of way violated federal law, then the federal court will get involved. But when you initially file that, they're just examining whether or not they can get involved. So when you file that 2254 petition, after you're done with the state review, what you do is you take all of the issues that you properly raised all the way through the state process, whether they were on appeal or on your habeas corpus. So say on your appeal, you raised 3 issues. On your habeas corpus, you raised 5 issues. You now have 8 issues that you could bring into the federal court so long as you are making them federal claims. So you take the 5 from your habeas corpus ineffective assistance of counsel claim, and your 3 from your appeal, and you put them on your 2254 petition to the federal court. So now the federal court has those 8 claims that they can review, and they're going to decide whether they can do something about it. But that process is called exhaustion, by bringing your issues through each stage of the state court proceeding. If your issues are not exhausted, they can deny your entire petition. Usually what they will do is just deny the unexhausted claims. So like say you have 5 or 10 or 8 claims, whatever, and 5 of them aren't, or 3 of them are not exhausted, meaning you did not take these 3 through the entire process. Some kind of way along the way they failed. You failed to bring it up. Doesn't mean that you have to win, but means that you didn't timely submit it to the next court. You didn't do something that you were supposed to do. So if you didn't bring your issues up properly, then they're not exhausted. Then the federal court can deny your case, or they can send back the unexhausted claims to the state and say, you got to raise these. We will hold your other claims here, what they call in stay in abeyance, and then we will wait for you to exhaust the unexhausted claims, or you can drop the unexhausted claims and then just proceed with the exhausted claims. So when you're in the federal court, now you're in the lowest of the federal court, you're in what they call the district court, United States District Court. So you're in the federal court system. The state court system is made up of, in this regard, for the criminal process, the general district court, which is where you have your preliminary issues at, the circuit court, which handles the felony cases, and then if you get convicted, you have the Court of Appeals, Virginia Court of Appeals, and you have the Virginia Supreme Court. Right. So those are your courts. So if you're in the federal court and you put your issue on habeas corpus, you have the United States District Court, then you have the Circuit Court of Appeals. So we're in the 4th Circuit. So you have the 4th Circuit Court of Appeals, like we're in the hardest circuit of all the circuits. So you have the Fourth Circuit Court of Appeals, and then you have the United States Supreme Court.
Right.
So when you're going from the district court, what you're doing is you're and what you're doing whenever you present these cases, you're trying to use their court cases as precedent, that you're weighing what happened in your case against their cases. Other cases outside of the state or outside of that circuit or whatever court you're in outside of that district, they're not all the way authoritative. They grant more weight to what they do than what other courts do. So that's where you say there's things that's called authoritative arguments and things that are persuasive. So when you're persuading, you're making a persuasive argument. You're using other cases and other circumstances to create a picture in why you should be granted relief. You're persuading them a certain way. Sometimes that circuit or that court did not make a specific decision about that issue, and you have to draw from other places to create a picture of why you should be granted relief. So what you're doing mostly, and that's a problem, a lot of people, they don't comprehend that you got to pull from where you're at, because that's what that court is working on. Their case law, what they call case law. Really, courts are not supposed to write law from the bench, but they do it every day.
Right.
Because the law is the law.
Right.
But they have what they call case law, which is their body of law, which is what they will call like res judicata, which means we stand by these decisions that we've already made before, or stare decisis. That's what that also means. So they draw from what they have opined and they apply it to that, and they say, well, this is what we see, how we see the situation here, and this is how we're going to roll. Unless you show us some major reason why we should not move like that. Now, when you go to the circuit court from the district court, what you're doing is you're saying, well, maybe this district decided this like this, but I can show you where this other district and this Fourth Circuit decided it like this, or where you as a Fourth Circuit Court of Appeals have decided it in another way in my favor. So this is why you should overturn what they did.
Right.
So you're doing that through, and then when you go to the United States Supreme Court, it's the same thing. You're demonstrating how the United States Supreme Court may have ruled, and their decision is inconsistent with their decision-making process, or how another circuit, if you were in another circuit, this would have went in your favor. Instead, I'm in the Fourth Circuit and they're ruling against me like this. So you're getting them to decide a conflict between the circuits or conflict between the states. So that's what you're doing when you're going through that appellate process, and you're doing it with your habeas corpus. Is basically ineffective assistant counsel claims that should have been raised but were not raised because your lawyer was not good. You know what I'm saying? Basically, your lawyer was not functioning as a lawyer under the law.
I have a quick question, and I don't mean to interrupt. I mean, this is very detailed information. You and I spoke a couple of days ago, and you were explaining to me that if you are in a certain institution, and I think we said if you were in a county jail versus the state or the federal, that if you started the paperwork in the county jail, that there is certain courts that paperwork is sent to. But if you get transferred to another facility, from my understanding, you have to start that process all over again, right? Because it's under a different legal system, correct? Or am I wrong?
Not necessarily. Like it all depends on what we're talking about. But if you're talking about something that relates to your conviction was in whatever court it was. So that never changes.
Okay.
You're supposed to notify the court when you move. So if you get transferred to another facility, you have to notify them that, look, I'm not at that facility, I'm at this other facility, so they can send your paperwork there.
Okay.
But what happened doesn't change just because you physically went from one court to another court. So if that's what you're talking about, I'm not sure. But now, like, say if you were dealing with, I mean, when we're talking about, we haven't addressed this yet, but when we're dealing with like civil actions against a jail or something like that, yeah, it does matter where you're at, because a lot of times they close off those cases by sending you to another facility. So
Okay,
what
yes,
they'll say, well, that issue is moot. Like whatever you're asking for, you want some situation to cease to exist, or the prison to discontinue a practice. Well, they've already taken care of that by sending you somewhere else. So um, in that circumstance, where you are does matter, but there's ways to there's ways to deal with that too, because that's common practice. They're always going to do that, especially if the basis of your claim is saying you want an injunction. So if you want an injunction, basically you're saying, I want the court to make them stop doing this thing to me right now. And they say, fine, we can resolve that by sending you somewhere else. So we can moot your request for injunction, so the court doesn't ever have to rule negatively against that facility. And now if you have a problem, if that was the whole basis of your claim, that you wanted an injunction, then injunction solved. Now, if you want damages for what had happened up until that point, then whether they transferred you or not, it wouldn't make a difference.
okay, I
So,
think we were, not to cut you off, I think we were discussing if the county level, the state level, the court system.
oh, okay, I
Yes,
know what you mean.
yes,
Like, okay, so that deals with whether a court has jurisdiction to hear your case,
correct,
like to
correct,
continue to hear your case after a certain point. So say you were convicted, and what in Virginia they have what's called Rule 1-1. Rule 1-1 is like the fundamental to really all court actions. It gives them jurisdiction and it concludes jurisdiction. So Rule 1-1, that's why it's called 1-1. It deals with the extent of the court's jurisdiction. So as long as you are in this criminal issues, as long as you are in that court and it has been within 21 days of their decision, the court maintains jurisdiction. When that time has expired, the court, the circuit court cases, like we discussed before, like if you're in the United States is made up of multiple corporations, and
correct.
the United States itself is a corporation. So it has the United States itself is a corporation. Then you have the sub corporations, which are the states, really, but they're supposed to be over the United States, but they act as sub corporations. And then you have sub corporations in the states, which are the circuits, which are sub corporations, but they change their name to circuit. So if you have a issue that you were convicted in a circuit court, the circuit court can maintain jurisdiction for a period of time because they are delegated the ability to carry out laws in their circuit. So they have the Virginia Code, right? That they grant these circuits, they basically deputize them or give them the authority to enforce the code. Really, it's the state code that they are enforcing inside of a county or a circuit. So they give them a certain limited jurisdiction to do so. And then once they've done it, they have to pass that case to the state. So when you are finished with your the 21 days has expired, the time that they extend to the court to handle that issue, and then you have 21 days after that to make your little corrections or whatever you need to do. After that got to go in a box basically, and now it's going to the state. So now your case is passed over to the state. The circuit court loses jurisdiction and it's passed over to the larger corporation of the state. Even
So
when you are
if
physically moved into the
right, so if the circuit court handed down, I think we had talked about this. We had said that if the circuit court or the county hands down, that, okay, well, you've done 3 years, we're gonna, just give you, probation, time served for those 3 years. And then 2 days later, you get transferred to another facility. So then the whole law changes because you're not any longer underneath that jurisdiction, correct?